to begin the introductions.
Good morning and nice to see you again. We're going to start off with the judges introducing ourselves, and then we'll ask you to introduce yourself and your teacher. I am Deshawn Whitaker, We the People teacher in Charles County Public Schools in Maryland.
And I'm Joe Stewart, teach political science at Clemson University in South Carolina.
And hi again, I'm Diana Owen. I'm political science professor at Georgetown University in Washington, D.C.
All right, and please introduce yourselves.
Hi, we are Team Jefferson. We represent Mr. Bannister's 7th period class at Lakeside Middle School. My name is Peyton Bowman, and an interesting fact about Thomas Jefferson was that he was an astronomer.
Hi, my name is Drissa Jones, and Thomas Jefferson loved French vanilla ice cream.
Hi, my name is Ava Jane Meyer, and an interesting fact about Thomas Jefferson was that he was an archaeologist.
All right, love your fun facts. All right, so we are preparing for Unit 4, Question 2 today, and I will read the question. If a law has been properly passed by the lawmaking branches of a democratic government, why should judges have the power to declare it unconstitutional? Do you agree or disagree with Robert Dahl? Why? What is judicial review and why is it controversial? What has been the impact of judicial review on American society? Once the Supreme Court has decided that a law is unconstitutional, what power, if any, do the people have to change the Constitution? You may begin.
Once upon a time in a government long ago, there were two men who had a love-hate relationship. One became our second president,
John Adams,
the other his vice president,
Thomas Jefferson.
Their political differences and tedious relationship would ultimately lead to judicial review.
As Adams' presidency was ending, he tried to pack the federal courts with men of his political liking. The problem was that his Secretary of State, John Marshall, was slow to deliver all of the messages. The next day, when Jefferson was sworn in as president, his new Secretary of State, James Madison, was prevented from delivering the remaining notices.
These actions would lead to the case of the Marbury v. Madison 1803, which established judicial review, a power that the Supreme Court now possesses.
Judicial review is the power of the courts to decide whether laws and actions of government are allowed under the Constitution. Once a law is passed, the Supreme Court has the right to review, and if viewed as unconstitutional, it will be declared null and void.
One of the people who didn't get a promised job was William Marbury. He took this to court.
In that case, it was ruled that William Marbury was due his federal appointment. However, the Judiciary Act of 1789 was ruled unconstitutional because that act gave the Supreme Court the power to hear his case, which the Constitution does not allow.
And who became the Chief Justice of the Supreme Court that would decide the Marbury case and deliver judicial review as a riveting power that it possesses today?
None other than John Marshall himself. Can you get any more dramatic than that?
Thus, the Supreme Court lost the opportunity to hear these cases. However, it acquired status by gaining the power of declaring laws unconstitutional.
Prior to this case, the Supreme Court was seen like a stepchild to the other two branches. The Supreme Court gained recognition, respect, and authority to protect and enforce the Constitution.
So, back to the original question, we agree with Robert Dahl. There is not one single law that every American citizen will like or agree on. Laws should stay in the place once they are ratified.
Judicial review is controversial and not say in the Constitution and doesn't line up with the ideals of democracy. By that, we mean the democratic process lies with the power of the people.
So what choices do the people have as a counter-argument to judicial review?
This is where the states come into play under the 10th Amendment. Laws not governed by the Constitution can be written by states. Examples include marriage license, speed limits.
26 states have the power of initiatives and referendums. This is where the people have the right to create or reject legislation. Opponents state this is the power of the mob and violates Article 4, Section 4 of the Constitution, where every state is guaranteed a Republican form of government, where in reality, this provides a safety net for the people in the lawmaking process.
In the state of Washington, the legislature passed a law in 2012 allowing same-sex marriage. A referendum was put out by the citizens against this law. It got enough signatures, went to the ballot, and yet the people voted in favor of the law, thus it stuck.
The initiative referendum process is an alternative to judicial review, but only at state level.
It is often stated that one does not want to see the sausage made, the lawmaking process, but simply to eat the sausage, live within the confines of the law. With the legislative process, the taste of the final product is actually more appealing than the process that went into making it.
To add to this metaphor, the condiments that are added to the sausage is the work of the Supreme Court, the ultimate spice of life that makes everything taste better.
In plain language, judicial review prevents constitutional laws from being violated, and the initiative referendum process allows the people this opportunity at the state level.
In essence, this is making the sausage and eating it too.
As the sausage hits the bun, this concludes our presentation.
All right, we're going to begin with our questions. If the courts did not have the power of judicial review, how could the powers of majorities in legislatures be checked?
Could you maybe rephrase the question?
Sure. So let's say the Supreme Court did not have the power of judicial review. And when a law is passed in the legislature, it's passed by majority votes, right? So how could we check that?
I think none of my colleagues and I know how to exactly answer this question at the moment. Would it be okay if we get back to you on that?
Sure, I'll ask you something else. No worries, we'll forget that question. All right, so do you think that judicial review is needed for us to protect the rights of the minorities against the will of the majority?
I do, because it's kind of like the case of Marbury versus Madison. The minority would have been Marbury in that situation where he didn't get his job appointment. And if it wasn't for judicial review, then it would have been extremely unfair to him and he wouldn't have got his job appointment. And I think there's a lot of cases that have been like that, where there have been examples of the minority not getting a great situation handed to them, and judicial review can help to make it better.
I agree with my colleague, and I think a good example of this is the case of Love versus Virginia, where laws regarding interracial marriages went under judicial review and were repealed because they had a lot of racial discrimination. So, in my opinion, judicial review helps the minority in that sense.
Okay, you've said that the courts have the power of judicial review, but are there limits in the sense that can judges just kind of say, oh, we were reading the paper today and we saw this law the Congress or the legislature pass, and we think that's unconstitutional? Or is there something that has to happen before that power can be exercised?
No, because they can't just go and do that on their own. That's where we were talking about initiatives and referendums, those come in. Somebody has to make an initiative, I believe, and take it to the courts, and then the Supreme Court can decide if it's unconstitutional.
So, do you think that the Supreme Court justices should be elected by the people, or do you think that the system works as it is, where the Supreme Court justices are appointed by the president and confirmed by the Senate?
In my opinion, I think that the Supreme Court justices should be elected by the people because since they have that seat for life once appointed by the president. I think it's important that the people vote that person in because they're going to have so much power for such a long time. So it's important that the people know what they want for that position.
I agree with my colleague on that. I think the people should have say, or at least like with the example of Justice Ruth Bader Ginsburg passing away recently, and President Trump having to put in a new justice, Amy Coney Barrett. I think maybe like even if the president can still decide, they should make it more equal. Whereas Ruth Bader Ginsburg was more of a liberal thinking type of justice. I think that if they're going to replace someone, it should be with someone of the same beliefs, so then it's more even if the people can't decide.
All right. Let's stay on that path for a little bit. So let's talk about the life term of the justices. Do you think that's fair?
In my opinion, I think it is not really fair because they're like the only ones who have to do that job for so long. And I don't really think it is fair because while everyone else gets like terms for like 2 years or 3 years, they have to do it for the rest of their life. And like, what if they don't want to do it anymore? Like, it's just not really fair that they have to stick with that.
I agree with my colleague to an extent. I think it should be in terms like 2 years or 4 years or 6 years, how it is with other branches of the government, because that's a lot more fair. Also, what if there's a justice that isn't maybe the right fit for the country? I think having them be there for life might not be the best for the nation.
I agree with my colleagues, and in my opinion, having someone in some political position of power for life seems unconstitutional for me, because that's why we have terms in all of our other branches of government, because of not wanting to have this tyranny, basically, which is what we didn't want when we broke away from Britain's rule, because we wanted to be able to elect our leaders and have that fairness in our government.
Yeah, to what she said, it doesn't really line up with democracy. And because we are a democratic, well, not democratic, but we are a democracy, I think it is unconstitutional, like she said. And it's more like a dictatorship or like the king was.
So why did the founders of the Constitution set it up like that?
Could you maybe rephrase the question?
Yeah, well, I mean, you've made the argument that this is undemocratic, and yet we've got these people who wrote the Constitution. They set up this system of government we have, but they set up this particular branch of government in a way that, as you describe it, is undemocratic. Why would they do something like that?
I think the people who wrote the Constitution set it up that way because their intent with the Constitution is that the people would be able to trust the government and what is written in the Constitution to run our government fairly, which is about what we talked about yesterday with the Federalists. Believe that the Constitution basically wrote out everything that was needed for the country to be run fairly. So I think that's why they set up the government the way that they did, because they truly thought that was best for the people.
You get the last word, Russell. Here we go.
All right. I appreciated our conversation today on judicial review. You have a very clear understanding of Marbury versus Madison and how, the relationship with Adams and Jefferson, pretty interesting from during that time. And then you mentioned how the irony of John Marshall being on the court later on in deciding this case. I like how you mentioned the court cases about Washington State and the marriage law. Loving, of course, that case was also very interesting for you to put in there. I like in your follow-up how you discuss how the controversy behind Trump and having the seat not remain vacant and him appointing Amy Coney Barrett to the Supreme Court during such a contentious time. And I enjoyed your discussion. I love your approach to the questions and how you present those. Very well done.
Yeah, I agree. I very much enjoyed our discussion. You're wrestling with some important issues, and I like the fact that you referred back to what we talked about yesterday. You see that all this is tied together. This isn't, okay, I'm doing this question today, and I can forget about what I'm doing today and move on to the next one. I like the fact that you brought in the state level, the initiative and referendum, and correctly point out that not all states have that. And so it's a really interesting situation. We're about to see the state of California once again go through a recall election on its governor, and yet a lot of states don't have that. And so the checks that people have, I think, are good to recognize. Think about how we staff the court. In each of the other branches of government, there are constitutional requirements. There's an age requirement, a residency requirement, but not for the federal courts. Each one of you is constitutionally qualified to be a Supreme Court justice now. And so I look forward to you being on the court. I will, if you can get yourself appointed to the court, even a lower level federal court, I will lobby with your teacher to make sure you get an A in this class too. So keep up your good work in studying the Constitution. You've done a good job and you should be proud of yourself.
I agree with my colleagues. I thought that you had a strong opening statement, and I like the way you told it like a story as it was unfolding. As you said, wow, there's there's a real drama here, and the way that it ends up with Madison in the end, it's really even though it's a landmark Supreme Court case, I think the kind of history surrounding it and the characters involved make it really compelling. I like the fact that you actually stated up front that you agree with Dahl and tried to argue that case. And you brought in different amendments to the Constitution and how that worked. I particularly appreciated your answers to my question about, should we stick with the way that that Supreme Court justices are chosen, or should they be elected by the people? And just throughout all of your conversation, you're pretty consistent with the fact that you want the people to have the power. You don't want the power to be in the hands of, kind of government officials or people who, kind of might be elites and not the public. So I thought that was good. And then talking about the idea of life terms also, kind of being a problem because they, could cause, as you said, kind of you should have terms like the other branches of government, and that, you don't like the idea that there could be a potential for tyranny. And I also really appreciated the fact that you tied everything together, like my colleague mentioned, that you said, oh, just tying this in with yesterday's conversation. I thought that was really well done. And I liked your sausage analogy, and with the Supreme Court, it's so relevant because we don't see much, we don't hear of all the branches of government. What they do takes place, very much behind closed doors that the public doesn't get to see until we get, the Supreme Court decision. So really nice job.
I was going to say, for us, it's getting close to lunchtime. For you, that's breakfast sausage, but yeah, that was fun.